Another one from SQE1. Welcome back, you bright mind. And today we are stepping into the world of terms. So, terms in contract is a bit tricky, but once you just go through our discussion, I promise you will understand it, how it works. So, if offer and acceptance from the handshake, terms are what each side actually promised during it. A contract's content are simply in terms, the promises, duties, and rights that bind the parties. Terms tell us what must be done, how, and when. They are the rules of relationship. Now, these terms come in two flavors: express and implied. Express terms are the ones you actually say or write down. Implied terms are the ones the law slips in quietly when it thinks you have forgotten something obvious. And it is essential to tell terms apart from representations. Representation are statements made before the contract. The sales talk. If false, they may lead to misrepresentation. Terms, on the other hand, are promises that form part of the contract itself. The different the difference matters, and you need to understand the difference between these two. One leads to damages of breach of contract, and other leads to damages for deceit. So your job in the SQE is to decide, was the statement part of the bargain or just charming small talk? So at that point, that's very important to understand between terms and representations. And express terms are easy to spot. They are the ones you can point to and say, that's what we agreed. But how do they actually become binding? The law says a term is only incorporated into contract if it was made part of the agreement properly. There are four classic ways this happens, that how it becomes a term. First, by signature. If you sign it, you are bound. So, in Grokob case in 1934, a woman bought a vending machine and signed a contract. She said that I didn't read it, which excluded all warranties. The court said, tough luck. Your signature binds you, unread or not, like it was you who need to read it. A painful reminder that scrolling down and clicking agree has been legally dangerous for nearly a century. So be careful, long terms, especially I was signing a mortgage agreement and I just read everything at that point. It took me ages. But now you can do it easily as well. I won't say use AI, but use your understanding and give it a little time to save yourself. Second, by notice. When a term is brought to your attention before or at the time of the contract. In Parker case, a ticket stated that luggage was limited by conditions printed on the back. That was valid notice. So once you buy a ticket, careful, just go through it. Third, course of dealing. If two parties have dealt together before or on consistent terms, those terms can be implied into future contracts. It was David McBride case in 1964. For example, two businesses, they are conducting business and those forms become binding. And fourth, custom and trade usage. If a term is well known in an industry, it may be implied automatically, like a silent rule everyone in the trade just knows. Even if no one bothers to write it down, things which are already practiced in certain areas of business. And those are obvious. Take Ollie's case from 1949. A couple checked into a hotel and only later saw a sign in their room, hotel not responsible for stolen items. The court said, too late. The contract was made at reception, not in the bedroom. The sign might as well have said, Nice try. So at that point, it does not apply. So timing is everything. A term cannot be sneaked in after the contract is formed. That's what we need to keep in mind. So the term cannot be agreed after the contract has been signed in this way, as it was in Ollie's case, in very deceitful fashion, I would say, like it was done. Then we have Inter Foro Picture Library case from 1989, an especially British name for a case about overdue photo slide. So the delivery note said said there would be a massive daily charge for late return, but this was not made clear. The court said such an onerous term need very clear notice. You need to point it out, like the rule, the more unusual or severe the term, the more effort you must make to tell the other party about it. No one likes nasty surprises, not even judges. For example, you go to buy a gym membership and they say that if you disappear after 2 weeks, you will be paying the gym £1,000, and they just write it very small. At that point, of course, court will favor you, not the gym guys. Although how moral they were at that point to take you to gym. So now representation we terms like this is asked many times in your SQE exam. Forget about case laws sometimes, just try to just have understanding of those case laws. I have written it on slides to signpost everything, because not only SQE1 students will benefit from it, LLB people can also find it useful for their exams and understanding of law. Not only LLB students, but also common folks can understand it. So now, not every pre-contractual statement makes it into the final deal. Some are just periphery, mere words of persuasion. Like I have a car, I'm selling it, and I say, it's a wonderful car, unbreakable and all. That's a mere puff. You have just gone through ads of like Red Bull. It gives you wings. No, it does not. Don't jump off the roof. So the key question is, did the parties intend the statement to be binding? In Rowledge's case, a seller told a buyer that a motorbike was 1942 model when it was actually older. Because some days passed before the written contract was signed and the statement was not included, the court decided it was representation, not a term. Contrast that with Dick Bentley's case. A car dealer claimed a used Bentley had gone or done only 20,000 miles, when it had done much more. The dealer was an expert. The buyer relied on him, and the court held it was a term. You are an expert. You understand car business. And at that point, you are responsible for what you said. So when deciding whether statement is a term or representation, look at timing, expertise and reliance, all of it together to just distinguish between term and representation. If an expert makes a specific claim right before the contract, it is probably a term. If it is casual chat from someone unqualified, it is probably sales better and possibly false, but not contractual. For example, if I make a statement about this laptop in front of me, I'm trained in law, I'm solicitor, I just at that point I understand law. I don't understand how it works, like the pixels and blah blah blah. So my obligation will be different from the obligation of someone who is software or hardware engineer in computer science. So the next thing is implied terms. So the law occasionally steps in and say, you clearly meant to include this, even if you did not. These are implied terms and they are added to make contract workable or fair. There are four main sources: statutes. Parliament adds term to protect fairness, such as in the Sale of Goods Act and Consumer Right Act. Certain things are understood and included. Common law, courts imply terms necessary for the contract to make business sense. For example, I rent an electric scooter and there is no battery. It was not written that in contract they will give me battery in that one. So that will be already implied that I got it to travel and battery must be included. Custom or usage, trade practices that are so obvious they don't need to be written at that point. Implied in law, general duties implied into certain type of relationship, such as landlord and tenant. Even if you write a general landlord-tenant agreement, certain things will fall into or implied under law. The classic case of implication in fact is the Moorcock case from 1889, where a wharf owner allowed ship to dock, but the riverbed damaged the hull. The court implied a term that the wharf would be safe for mooring. Otherwise, the contract made no sense. The judge calls this the business efficacy test. Does the contract work without the term? If not, it is implied without writing it. So, terms implied by statute. That's what sometimes tested. Yes, there were a couple of questions on it. Some terms do not need to be guessed because Parliament has written them. For example, the business contract, like Sale of Goods Act. Under Section 12, the seller has the right to sell. 13, goods must match their description. What you show, you should just match them. 14, goods must be of satisfactory quality and fit for the purpose. If I requested a cake, it does not mean that it is a cake, but it is rotten. It does not fit the purpose. 15, good must correspond with any sample provided. You show me Dyson Hoover and then you bring something XYZ. At that point, it must correspond with the sample that you have provided me. For consumer contract, turn to Consumer Right Act 2015, goods must be of satisfactory quality, fit for purpose, and as described. Services must be performed with reasonable care and skill. Digital contents must meet similar standards. Yes, even your dodgy phone app can fall under it. Okay. These statutory terms automatically apply and cannot usually be excluded when consumers are involved. It is Parliament's way of saying we have seen enough unfair contracts. Thank you. We will take care of it. So, classification of terms, condition, warranties, and innominate terms. Very, very important for your exam. Now, not all terms are created equal. Some are vital, others are less serious. The remedies for breach depend on which category a term falls into. So that might be tested in your exam. A condition is essential. Breach lets the innocent party terminate and claim damage. In Pozard versus Spires case, 1876, an opera singer missed opening night. Condition was breached and the producer could replace her. A warranty is minor as compared to condition. Breach gives damages only, no right to terminate. So in Bettany case from 1876, a singer missed rehearsals, not the opening kind of thing, but could still perform. This was just a warranty that they did not attend the rehearsals, but still they can perform it. Then came the innominate terms, and you need to understand it. Introduced in Hong Kong fair shipping case in 1962, the court decided that not every breach fits neatly into big or small. So it is not like condition, it is not warranty. The court decided that not every breach can be classified as that. If the breach deprives the innocent party of substantially the whole benefit of contract, they can terminate. If not, they can get damages. So it will be court to choose between them. So when in doubt, look at the effect of breach, not just the label the contract uses. So it is not what parties use, it is what law says. Interpreting contractual terms is very important. So we know what the terms are and how do we figure out why and what they mean. So the modern approach is objective, not subjective. Sorry, never, ever. Like at that point, it is subjective. What would a reasonable person in the position of 40s have understood the word mean? In leading case, it's like, the court decided that investor compensation scheme versus West Bromwich Building Society. Lord Hoffman, my favorite, gave us a framework for interpretation, saying the court can look at background, the metrics of fact, but not prior negotiation or subjective intent. So, in short, judges are not mind reader. They interpret based on context, not personal feeling. The goal is to find the meaning that makes commercial sense. If the contract is clear, the words rule. If it is ambiguous, the court asks what a reasonable reader, knowing the background, would think. Moral for exam and life: always draft clearly or risk leaving your meaning in the hands of someone with a wig. And also, you would have to pay money to get the big person decide. So, tips and pitfalls we will try to just look at. So, start every essay, it's not essay, every MCQ, but by understanding express and implied terms. Use different cases to understand it. Identify whether the contract is business or consumer. Both of these things will be totally different. So, classify terms as condition. So, warranty or innominate kind of things. So at that point, it will be easy for you to understand which law to apply on it. So, pitfall: treating every pre-contract terms as a term. So you need to check intention and timing, forgetting to discuss notice for unusual or hidden terms, ignoring the CRA 2015 when a consumer is involved, misclassifying terms, like, for example, remember, effect of breach is key. So what breach makes to the contract, how it impacts the contract. Overusing implied terms. Quote, imply only what is necessary, not what is convenient. Not at all. I hope it makes sense. If by any chance you did not understand it, go through it again, and I hope you will. Thank you very much for being with us. Ta-da.